All right, I think that takes care of the jail. The other one is appearing by Zoom remotely on her own. She was summoned to appear, and she has appeared on a summons. Michaela, it looks like we got you served in Wichita. It looks like there is a September battery charge, theft charge that got filed. And that's why you're notified to appear today. It's alleged that you had physical contact with Lori Jasso, Jasso. They call it done in a rude, insulting, or angry manner. So usually it's hitting, shoving, pushing, something of that nature as part of a fight or disagreement or out of anger. It is a B-person misdemeanor if convicted of battering someone. Maximum 6 months, $1,000 fine if convicted. And then it's also alleged that you took her purse and her cell phone and some stuff in her purse without her permission. The value less than $1,500, which also makes it a misdemeanor. It's a Class A non-person. It's always interesting that property crimes are a higher classification than person crimes like a battery, but that's how it's set out legislatively. The maximum sentence is 1 year in the county jail and $2,500 fine if convicted. I'm going to enter a not guilty plea for you. If you're employed, I'm going to ask that you make an effort to retain your own attorney. If you're not employed and you have dependents that you support, then I will appoint an attorney to represent you. You will need to go before our magistrate judge on January 26th. The time depends on whether or not you get a court-appointed attorney or you hire your own. But the date's the same in front of Judge Webster. I'm going to allow you to sign your own bond since you were brought in on summons and you voluntarily appeared. You'll need to make arrangements to sign a $2,500 bond, which means if you don't show up for your court appearances, we can take a judgment of $2,500 against you, issue a warrant. It's added to your court costs in your case. And then probably bondsman will have to get involved and you'll have a higher bond that'll be set for your future appearances. So that's kind of how a signature bond works.
A signature bond, often called an OR, own recognizance, or PR bond, basically means the same thing. It allows her to remain out of custody while the case moves through the normal pretrial process without having to post cash up front. Instead, she's giving her word that she'll follow the court's conditions and return when required. But that freedom is conditional, not permanent. A bond like this can be revoked at any time if the court believes the defendant isn't taking the process seriously or is violating expectations. And when someone goes on the record and starts making statements that raise concerns about judgment, compliance, or respect for the court, that bond can disappear very quickly. Staying out of custody depends entirely on behavior, and the margin for error is much smaller than people realize.
I am here as the representative of the entity that you speak of, but I'm the living woman, and I do not consent to these proceedings. So, and also, and for the record, I have the right I have the right to face my accuser, and they have to be a living man or woman. So, as far as that matter goes, therefore I move to dismiss the matter entirely.
Okay. Well, I move to order you to appear on Friday at 1:30 at the courthouse in front of myself, no matter what your name is or your affiliation. And to bring with you anyone that you are an agent of or you represent. If you don't appear, I'll issue a warrant for your arrest or for her arrest.
Your Honor, are you setting the $2,500 OR bond?
No, I'm not.
Okay.
No, I've got to see her face to face and get her identifiers and have you personally appear, and that's going to need to be in person here at the courthouse in my courtroom.
What was the date and the time for that, ma'am?
Friday at 1:30, courtroom A in El Dorado at 201 West Pine. That makes that, the 14th at 1:30, please.
Okay.
Okay, I appreciate it. If there's
Thank
nothing
you.
there today, though, we'll adjourn on this case. We won't proceed any.
That might honestly be a new speed record for getting a PR bond changed. It took barely a few sentences before the court decided that the signature bond wasn't going to cut it and ordered her to appear for a more formal bond review instead. That kind of shift doesn't happen by accident. It's usually a sign that the judge heard enough, fast, to question whether the defendant can follow even the most basic conditions. With that chapter closed, we're heading over to Michigan. This time, we're looking at a sovereign citizen defendant making his very first appearance, straight from custody, in front of Judge McNally. And for anyone familiar with Michigan courtrooms, you already know Judge McNally has a reputation for running a tight ship. He's direct, no nonsense, and not at all interested in courtroom theatrics. This is one of those matchups where unconventional arguments meet a judge who has heard it all before, and the outcome is usually predictable.
All right. Keynes, Timothy Neal Keynes, 23R513178.
Good.
Go ahead.
Okay, good morning, Your Honor. Alex Greenforth, PA2657, appearing on behalf of Timothy Michael Keynes, who's zooming in from the Wayne County Jail.
Did you talk to the prosecutor about this one?
I did not, because I have noticed that my client wishes to get some discovery, and I didn't see anything in the file.
Okay. All right, Mr. Keynes, your name?
Timothy Haynes.
How long are you in custody there for on other cases?
I have no clue. I'm waiting for my tether. This is holding me up for my tether. So I asked for a discovery for this case.
Yeah, I don't have a problem. I hate to see you sitting in there all day. It's too bad you didn't show up for several days. It's too bad you didn't show up when you were supposed to. Give me a new date on a Rockwood case, Lisa.
Judge, okay, I just want to be sure what we're doing here, because if we do discovery,
Hold him up.
this Mr. Green won't be here.
It's gonna go back to
Yeah,
Except for a pre-trial today.
right. It's going to go back to Mr. Gaith.
Okay, should we just have Mr. Gates talk to him today? It's on the docket for a pre-trial. I don't know if they realize that.
I think Mr. Green did, and his client wants discovery.
Yep. Of everything.
That's fine, Mr. Keynes. You don't have to.
Well, I mean, it's not no one else's freedom.
July 10th, 8:30.
Well, I don't know what you mean by that. We're trying to accommodate you here. I don't have any problem with you adjourning it.
Thank you.
Does he have other holds?
No, but this case out of, I think it was Taylor.
Okay.
And so that was a possession of some type of drug paraphernalia or something like that. I'm sure he missed a couple of court dates on that. And then he does have a bond in this case that he has posted of $250, $2,500, 10%.
That he hasn't posted.
Yes.
Right. Because he didn't show up on this one either.
I didn't have that.
Yeah, he's supposed to be here in 2023. What is all this yellow stuff all over this docket? Huh? Lisa? My grandkid's got the crayons out. And do you have any idea?
All right, that wraps up his first appearance. But this story is far from over. This was just the opening chapter, not the final act. As mentioned in court, he did have another scheduled hearing on July 11th, but that particular proceeding was never streamed or uploaded online. so there's no public footage available from that date. That said, we're not missing everything. About a month ago, he appeared again, this time in front of Judge Shackelford. And unlike the earlier hearing, this one was recorded. We do have access to that appearance, and it adds important context to how this case is developing. So next, we're going to take a look at that hearing and see exactly how things unfolded when he was back before the court.
On the file?
At anyway, July 10th at 8:30. Good luck, Mr. Keynes. We'll see you here then, okay?
Yep. Thank you.
Right.
Okay, thank you, Your Honor. But
So I stay here for another 10 days?
I'm not letting you out. You didn't show up here for 2 years.
The papers went to my house and my mom's
Listen.
house
No,
when I lived in Taylor.
sir. No. I'm not lowering your bond. I'm not giving you a personal bond. You've been playing with us. Okay? No. That's why I was questioning why you wanted to adjourn it, because you're not, unless you can post a bond, you're going to be sitting there. And I don't know how else to put
I'm
it.
suing those cops.
I'm sorry?
I'm suing those cops. This is
Go ahead.
horseshit.
Go ahead. Show up in court. You would have had your day in court. You'd have been acquitted 2 years ago. I'm not going to go on that. I could care less if you sue. Go sue whoever you want. Sue me if you want. Show up in court. Good luck. If you want to do something else, I'll be glad to have you get the police report from Rockwood and
Please do.
go talk to him some more. I don't have any problem with that.
no, I think that the major issue was he was looking for, and I did explain that the person don't guarantee a personal bond because he hasn't been missed in court case.
And he missed not only this, he missed Taylor too.
Right.
So this is not an anomaly. He checked something here. You know, it never fails. It never ceases to amaze me. Okay? He's got it worn out of Hazel Park, worn out of Southgate,
I had time for Hazel Park.
out of Bonia, worn out of Taylor, another 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 one out of Taylor. He doesn't show up on this for 2 years and he wants to talk to me about suing cops. Do whatever you got to do. I don't know who you think you are. You must be running the at least. Shut him off, Lisa. We'll see you here in a couple of weeks. I'm not going to listen to this nonsense.
All right.
Thanks.
Thank you.
All right, that hearing didn't have much action, but I still wanted to include it so you could see the full picture. Even when things seem quiet, those moments matter because they show how the case is progressing behind the scenes. Jury trials, as you probably know, usually aren't live streamed to YouTube. But if this one does end up being posted publicly, I'll make sure to bring it to you as soon as it's available. Now we're moving on to our next hearing, and this one takes us out to Colorado. It involves a sovereign citizen defendant I covered recently. After reviewing that newer video, I went back through my older content to track down the exact hearing they referenced, the one where the judge directly rejected his right to travel argument. I was able to find it, and it adds a lot of important context to what's happening now. If you haven't seen that earlier video yet, there should be a card above the screen that will take you there once this video wraps up. It's worth watching so everything that follows makes a lot more sense.
All right, this is the People versus Timothy Keynes. Mr. Keynes, if you can come on up, this is 230605, 230604, 230603, and 230602.
Good afternoon, Your Honor. James Gazicki on behalf of Mr. Kane. Mr. Kane is requesting a jury trial. And just for the record, I explained this to Mr. Kane that he's a sovereign citizen and I am not familiar, nor do I practice any laws regarding.
Because there aren't any laws regarding them, Mr. Gazicki.
Exactly, Your Honor. And I explained to him that I would represent him under the laws of the state of Michigan and obviously the United States.
All right, Mr. Kane, do you understand that? Is that a yes?
Yes.
Okay, so Mr. Gazicki has a law license and he's had it for a long time and he wants to keep it. So Mr. Gazicki is not going to come before this court or any court and make frivolous arguments or unfounded arguments on your behalf. But he has indicated that he would represent you on these cases, applying the law of the state of Michigan. You understand that? Is that a yes? Okay, she's taken down what you're saying and look at the same. Okay, so all of these cases are from the same occurrence, is that correct?
Yes, Your Honor.
All right, so one jury trial date. On March 13th, we have Leroy Griffer.
That's good.
That's you? Will that day work? That's the only
Yeah, it'll work,
trial?
yeah.
All right. All right, so we will set a jury trial date for March 13th of 2026. You'll be required to appear in person that date. And the trial starts at 9 a.m., so you should be here no later than that, okay? And sir, one second. Is there any potential that I should set a final settlement
I would
conference?
set a final settlement conference, Your Honor.
Okay, so we'll set one final settlement conference. All right, that's your jury trial day. We'll send you out notice in the mail of your final settlement conference as well as your jury trial date, okay?
All right, thank you.
All right, you're all set.
Yeah, have a good day.
The court denied your motion, plain and simple. As the judge pointed out, there is no recognized filing called a notice for record of impossibility that excuses someone from obtaining a driver's license, vehicle registration, or insurance. Those are legal requirements, not optional paperwork that can be bypassed with creative wording. What your filing actually signals is that, for one reason or another, you are unable to meet the basic conditions required to operate a vehicle on public roads. And that leads to a very straightforward conclusion. If you don't have the required credentials, you are not authorized to drive. Changing how you describe your status doesn't alter the law, and it doesn't create an exception. Public roadways come with clear rules, and without meeting those requirements, driving simply isn't permitted. End of discussion.
Thank you. Area code 719, last two digits 64. Who might that be? Area code 719, last two digits. Oh, Mr. Shadowins. Thank you for appearing, Mr. Shadowins. Good morning, sir. For the record, this is 25T262, 25T448, 25M318. I do appreciate you appearing. I guess I could call all your cases. Looks like you also have 25M395, 25M375, 25M352. Okay, so actually, in 25T448, Mr. Shadowins, I do need to advise you of your rights and of the charges. You have the right to remain silent. That means that you do not have to make a statement about your charges to anyone. Anything that you do say concerning these charges can and may be used against you in a court of law. You have the right to counsel. The court recommends that you have an attorney represent you. You may be entitled to a court-appointed attorney. If you are indigent, you have the right to request the appointment of counsel or consult with a public defender before any further proceedings are held. You have the right to a trial on your charges. You can have that trial in front of a judge or jury. You have the right to know the nature of the charges against you, which we'll get to in just a moment. Any plea which you make to the charges must be voluntary and not the result of any undue influence, pressure, or coercion on the part of anyone. You have the right to bail if the offense is bailable and the right to know the amount of bail set by the court. As a general advisement, if you are not a citizen of the United States, whether or not you have lawful immigration status, you should tell your lawyer, because you have the right to receive advice from your lawyer about the specific impact this case may have, if any, on your status. As a second general advisement, and I know this does apply to you, sir, if you are a current or former member of the U.S. Armed Forces, you may be entitled to receive mental health treatment, substance use disorder treatment, or other services. Do you understand your rights, sir?
Thank you, Your Honor.
Okay. I'm going to just advise you of the charges. There's first, failure to display proof of insurance, class 1 traffic misdemeanor, carrying possible penalties of 10 days to 1 year in the county jail and or a $500 to $1,000 fine, 4 points against your license. The second charge is driving under restraint, which is a Class A traffic infraction, carrying fines up to $100. The third charge is having a fictitious registration plate, Class 2 traffic misdemeanor, carrying possible penalties of 10 to 90 days in the county jail and or $150 to $300 fine. Finally, you're charged with having an unregistered vehicle, a Class B traffic infraction, carrying fines up to $100. Do you understand the charges and possible penalties in that case?
Thank you, Your Honor. Is the court and the people aware of my notice for record of impossibility?
No idea what that means, sir.
I was informed, I'll clarify, Your Honor. I was informed by the court clerk that my notices for record of impossibility to meet statutory requirements such as a driver's license, insurance, and registration due to service-connected disabilities. I corrected my status in equity, and I'm not surety for any of that. I cannot get a driver's license. There is no legal recourse or remedy, ma'am. So I clearly stated I was traveling, which I believe is a fundamental right established and upheld by the U.S. Supreme Court. So I would motion at this time to dismiss for a lack of Sixth Amendment nature. Please.
You may not have signed a piece of paper-labeled contract, but that doesn't change the reality of the situation. The moment you chose to operate a vehicle on public roads, you agreed to follow the rules that govern them. That's what a social contract is. Participation in a shared system that comes with responsibilities as well as privileges. Public roadways are funded, maintained, and regulated for everyone's safety. Using them means accepting licensing, registration, and insurance requirements, whether you like the terminology or not. You don't get the benefits of a system while rejecting the obligations that come with it. Driving isn't a private activity in a private space. It's a regulated privilege, and the rules apply to anyone who chooses to take part.
Mr. Parsons.
Your Honor.
You can just sit, that's fine.
The people are opposed to the pending defense motion to dismiss these cases. The stated reason is that the defendant cannot get a valid driver's license. The nature of the charges across all these cases go beyond just a no operator's license charge. My office has been in extensive communication with Mr. Shadowins. I'm aware that he is contesting these cases. I disagree with his argument regarding a right to travel as he has articulated it. People are opposed to the motion to dismiss.
Thank you. The court will deny the motion, sir. Under case law, People v. Zen 843p, second 1351, the court held that the right to drive an automobile on public roads is not a fundamental right. The courts have long recognized the right of states to regulate the use of motor vehicles on roads within the state. So I deny your request to dismiss based on a right to travel. So are you,
Would
Mr.
the court
Shadowins,
please
were you
clarify the Sixth Amendment nature, please?
I'm not even sure what you mean by that, sir, but
who is the
what
injured
your
party,
argument?
ma'am? I'll clarify. Who is the injured party? I am not aware of a victim or damaged property. I'm asking simply for clarity of the Sixth Amendment nature of, and cause of any of these cases. Who is claiming injury?
Well, sir, as when you drive, driving is a privilege, and the legislature has imposed regulations on what you must do in order to drive on public roads. So I guess the injured party would be the state of Colorado. You are being, all these cases are named state of Colorado versus you. There are other cases where, in cases where you're alleged to have resisted arrest and harassed people, though there are actual victims in those cases. So obviously that argument does not hold water. So Mr.
Objection, Four Corners rule, please. Can we please stick to the one case at a time, please, ma'am? And so, thank you. I don't have a driver's license. There's no contract. How can I be charged for violating a contract I never acquiesced or agreed to due to impossibility?
Exactly. What you just outlined perfectly illustrates the problem. The question of guilt isn't contingent on what evidence the prosecution chooses to show. It rests on your actual behavior. Treating it like a guessing game demonstrates a fundamental misunderstanding of the justice system, that a defendant should have a clear grasp of their own actions and be able to respond to charges based on facts, not speculation. Waiting to see what the state presents before deciding, am I guilty, signals unpreparedness and a lack of awareness of personal responsibility. In court, that kind of approach doesn't just weaken your defense. It invites the judge and jury to view you as someone who hasn't taken the proceedings serious.
So, sir, that is not a persuasive argument, as I've already mentioned. I am bound by the law of the state of Colorado.
I'm asking a question. I'm not making an argument, ma'am. I'm not presenting an argument, ma'am. I ask a question. Please, thank you.
I'm sorry, sir, but your question is nonsensical. So I am already told you that it is that under Colorado case law and statute, you are required to have.
Can the state be an injured party, ma'am? Point of clarity, can the state be an injured party?
Yes. All right, so Mr.
It's a body politic, is it not?
Mr. Shadowlands, I am not going to engage in these sovereign arguments with you right now. What I will tell you is, if you wish, we're going to give you another court date. I guess you already you've bonded out on, I guess, 3 of the cases recently. I mean, we can set them all over to December 1st at 8:30 if you'd like. Is it your intention to apply for a public defender or hire private counsel, or do you intend to represent yourself in all of the cases?
Sweet jurist, I have no choice but to represent myself. I haven't received much response from the people. I can't seem to get my questions answered. I actually was not arguing, ma'am. I'm just asking questions. So at this point, I will waive the court, request an Article 3 trial and discovery from the people, please, in all these matters, and we'll proceed by special appearance. Thank you.
Your Honor, if I may, these cases are not subject to Article 3 jurisdiction.
Are not subject to what? I'm sorry.
Article 3 jurisdiction under the federal constitution.
He's talking about the federal constitution, I know.
Your Honor, my office has been in communication with Mr. Shadowlands about the process for how to request and pick up discovery. We have also communicated, obviously, the WebEx information, which I believe he's utilizing to appear in court today. He is welcome to continue those conversations with the district attorney's office, specifically Investigator Schaff, who has reached out to him about the discovery process.
Okay, so you'll get your discovery. So do you want me to set your cases for trial, sir, or do you want to make an effort to apply for a public defender or hire private counsel?
If the people are ready to proceed with trial?
Sir, I'm sure they will be whenever it's set, but it hasn't been set yet. So are you wanting to enter not guilty pleas on all cases? And I can give you what's called the Arguello advisement and give you jury trial and pretrial readiness dates. I guess I would recommend, Mr. Shadowins, that you talk with an attorney before you do that. But I guess, you know, you do have the right to request that trial be set if you'd like.
Thank you, Your Honor. I think it would be improper to plea at this point without said discovery.
As I mentioned, that video has already been covered, and it's definitely worth watching. The judge completely dismantles his arguments. The remainder of this footage is mostly just the judge reading through the multiple charges against him, so there's not much new to add here. I'll leave it at that so you can check out the previous video for the full breakdown that if any of these cases have follow-up hearings, and judging by this one, they almost certainly will. I'll make sure to bring those updates to you as soon as they're available. Final thoughts. Happy holidays, and thanks for sticking around. If you enjoyed this video, hit the like button. If not, go ahead and hit dislike, but make sure to leave a comment below with your thoughts. And don't forget to subscribe with notifications on so you never miss any of my future content.